we've uncovered some additional data points speaking as to why the United States Supreme Court rescheduled the conferences in both the quote-unquote assault weapon case of Bianchi or Snope versus Brown, as well as the magazine ban case out of Rhode Island, Ocean Tactical. We're going to talk all about these dots that I've just connected when we come right back. You're going to like it. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a nominee in the category of top voices of the 2A for a 2025 Gundies Award. You can vote until December 17th, I believe. You can vote every day until then. And we've been a finalist in a lot of Gundies categories over the year. We've never won one, but this year I feel like we're going to break through. Got the candles lit and everything good like that to see if we can break through and win a Gundy 2025 Gundies Award, top voices of the 2A. Vote for Four Boxes Down or Mark Smith if you are so willing. Okay, folks, so here's the story. I've given further thought, and my views have not changed on the good news that I think has arisen from the fact that the U.S. Supreme Court has rescheduled the conferences in the Snope versus Brown case, as well as the Ocean Tactical case. But I want to give you some further data point that I think corroborates what I was saying, which I think this is very good news. To begin with, just to remind you what happened here, is that you have 3 pending Second Amendment related cases right now speaking to arms bans. You have the Bianchi or the Snope versus Brown case dealing with Maryland's semi-automatic rifle ban, assault weapon ban. That is that is an arms ban, meaning that's a firearm ban in the classic sense out of Maryland. Fourth Circuit Court of Appeals said, no, that's not a violation of the Second Amendment. Clearly that's wrong because they misapplied Heller. That's the first one. The second case, of course, is Ocean Tactical against the state of Rhode Island. Rhode Island has a magazine ban. You can't have magazines more than 10 rounds. We don't need to get into the details, but that's basically the gist of it. The thing about the Ocean Tactical case is, unlike the Snope case, which is a final judgment, meaning the case is over, the Ocean Tactical case is on an interlocutory appeal basis, meaning it arose from a preliminary injunction case. So that's quite interesting. And now what happened is that both the Ocean Tactical magazine ban case and the Snope assault weapon, I'm going to call it euphemistically or propaganda-wise assault weapon, just so we know what we're talking about, but the semi-automatic rifle ban case, those were supposed to be conferenced by the Supreme Court this week. And specifically, what that means is a conference occurs when all 9 justices sit in a room by themselves with no one else there, and they vote whether or not to hear the case on the merits. Specifically, they decide cert petitions. As a reminder, a petition for cert is a request by people for the U.S. Supreme Court to grant cert and hear the case on the merits, and decided the vast majority of people that seek cert are turned away. Thousands of them are turned away every year. The Supreme Court only grants cert in about 70 cases a year. And as of this moment in time, the Supreme Court has no pure Second Amendment case that it has granted cert to. There's 2 gun-related cases, Second Amendment-related cases. One is the Smith & Wesson versus Mexico case dealing with PILCA, the Protection of Lawful Commerce and Arms Act, which the government of Mexico sued the American gun industry. They're going to hear that case. That's not technically a Second Amendment case, although it implicates the Second Amendment. It's not technically about the Second Amendment. And you, of course, have the VanDerStok case. I suspect what's going to happen with VanDerStok is as soon as the Trump administration gets in there, they're going to have their attorneys write a letter to the Supreme Court that say, we're going to reverse all the Biden gun control regulations that we don't think should have ever occurred because we think they're all illegal. And they're going to write to the Supreme Court a letter that says, put on pause, don't decide this case because it's going to be moot. And I think that's the sort of thing that Chief Justice John Roberts really likes, because he is a big, he's very persnickety, if you will, on issues about case and controversies and mootness, and is happy to get rid of cases that he doesn't have to decide. So I think that's probably what's going to happen. I don't control the Trump administration, obviously, but I suspect that's what will happen. Only time will tell if my prediction proves correct. Okay, with that said, these 2 Second Amendment cases of Snope and Ocean Tactical were up for conference. They were going to be voted on, but then they got rescheduled. Now, any justice by themselves can ask for a rescheduling, but here's the thing. It's pretty clear to me that the Supreme Court has some plan in place to handle something associated with the Second Amendment directly this term. And I think it's going to deal with one of these arms ban cases. And why do I say that? Because the Supreme Court has already denied cert. Listen carefully. This is new data. The Supreme Court has already denied cert for this term in Second Amendment related cases. For example, just last week, I reported on how the Supreme Court has denied cert in the Wilson versus Hawaii case, which is the Spirit of Aloha case. Now, that was a Second Amendment case. They denied cert outright on that. Likewise, in the Maryland shall issue case against Anne Arundel County, dealing with certain restrictions on what gun stores have to post, that was also denied cert, although that's more of a First Amendment case. So the reason why I mention this is this. If the Supreme Court was just thinking about, we're going to take a Second Amendment case and we're going to put the rest on a shelf, and that's all we're going to do here, that they could have done that. But the fact is that the Supreme Court has already been denying cert outright to Second Amendment cases, to pure Second Amendment cases like the Spirit of Aloha case out of Hawaii. That they've been denying cert on Second Amendment cases, but they did not deny cert in these arms ban cases of Ocean Tactical and Snope. Tells me that they've got a plan in place, or they're thinking about what their plan is in place. Because the other thing, and this is the other critical data point that I want to bring to your attention that I don't think anybody else has connected the dots on. You probably remember back in October, the end of October, right before the election, I pointed out to you there was something significant happened in the case of Rigby versus Jennings. Rigby versus Jennings is the case that arose out of Delaware, dealing with the standards for what is a preliminary injunction, or when a court should grant a preliminary injunction in Second Amendment related case. And in that 3-judge panel decision by the U.S. Court of Appeals for the Third Circuit, handling that case arising out of a Delaware gun control law in Rigby versus Jennings, what happened there was the 3-judge panel of the Third Circuit in that Second Amendment case said that a Second Amendment plaintiff trying to get an injunction, a preliminary injunction, has to satisfy all 4 elements of the traditional standard of getting a preliminary injunction, which includes you have to show that you're likely to succeed on the merits, that there'll be irreparable harm to the people bringing the lawsuit if the injunction is not granted, that it is a balance of the equities, and that it's in the public interest. Now, those 4 elements, historically, in virtually all aspects of constitutional law, is once you show that a government law is likely to violate the Constitution, the injunction issues. The reason why that is, and this is what to understand about Rigby versus Jennings, and you'll see why this is significant in one moment to what I think the Supreme Court is about to do in the next couple of weeks involving the Second Amendment, is if there's a finding that the gun control law violates the Second Amendment on its face, it means that all 4 elements have been satisfied for a preliminary injunction standard, because once you're likely to succeed to show that a government gun control law is going to violate the Second Amendment, then there's no balance of interest here, because the government has no interest in enforcing an unconstitutional law. Obviously, it's an irreparable harm, because, again, I keep going back to what is irreparable harm. Irreparable harm is something that I cannot receive monetary compensation for as a general matter. So, for example, seriously, I want you to pause for one moment and think about this yourself. I want you to think about this. If I prevent you for the next 18 months from owning an AR-15, okay, I say you can't own an AR-15 of any sort for the next 18 months, let's say. How would you realistically put a monetary value on what you've lost from not being able to own an AR-15 in the last 18 months? If anything, I may have even saved you money, right? Because you didn't go out and spend $1,000 or more on an AR-15. You didn't spend a lot of money on ammunition for that AR-15. You didn't spend money to go to the gun range to shoot your AR-15. You didn't spend money on gas to drive to the range to shoot your AR-15. So if anything, I have saved you money by preventing you from owning an AR-15 semi-automatic rifle for the last 18 months. See what I'm saying? So that's the point. But still, the reason why it's irreparable harm is because there's no real way to measure the financial harm that you've suffered by not being able to own that firearm. But the fact that your Second Amendment rights have been violated is irreparable harm. You've suffered an absolute harm. It's just you can't measure that harm in monetary damages that readily, and that's why it's always irreparable. So again, the public interest has no interest in enforcing unconstitutional laws. So every court in America says that if there's a violation of the Constitution by the government, the injunction is to issue. There's extremely few exceptions we don't need to get into involving election law, but the bottom line is if there is a violation of the, if the plaintiff seeking an injunction is able to establish that he is likely to prevail, that's it. The preliminary injunction is to issue. And that's what that Rigby versus Jennings case issues, because the Third Circuit actually came out the reverse and said, no, there's a lot more that has to be proved by a Second Amendment proponent. And that's clearly wrong in anti-Second Amendment. So the reason why you got to understand this is because the Rigby versus Jennings case, if you may recall, the state of Delaware asked for an extra 30 days to submit their papers. And if that extension had been granted by Chief Justice John Roberts and the Supreme Court, it would have meant, and listen carefully, that the Rigby versus Jennings case out of the Third Circuit would have been pushed automatically because of the briefing schedule in the Supreme Court land to next term, 2025 to 2026. But Chief Justice John Roberts and the Supreme Court denied that extra extension of time. They only gave him a few extra days to file their brief to make sure that the Rigby versus Jennings Second Amendment preliminary injunction case could be heard this term. Which means, if you look at the whole gestalt of what's just happened here, they're rejecting Second Amendment cases on their face, such as the spirit of a law hogging. They're denying cert in Second Amendment cases. But they're not denying cert on the assault weapon ban out of Maryland and Snope. They're not denying cert yet in the Ocean Tactical case. And they've expedited the briefing schedule in the arms ban case out of Delaware and Rigby versus Jennings dealing with preliminary injunction standards. So why is the Supreme Court manipulating, if you will, that may not be the perfect word, but adjusting, if you will, the briefing schedule in Rigby to make sure that case is heard in conference this term while rescheduling the conference in Snope and the conference in Ocean Tactical? And it's pretty clear to me what all of this gestalt of information, now I know we're reading tea leaves, but I'm not so bad at this. I probably should do a video of how well we predicted the last term. But for now, I think what's happening here is the Supreme Court justices internally are looking at these three cases and asking themselves, well, how do we resolve this? We clearly know what the answer is. I mean, all you have to do is take now Supreme Court Justice Brett Kavanaugh's opinion when he was a judge on the U.S. Court of Appeals for the D.C. Circuit when he wrote in the Heller 2 case that AR-15 bans, semi-automatic rifle bans, clearly violate the Heller standard, and apply it to this case. And I don't think the magazines are going to be that difficult. I think the AR-15 case is super duper easy. The magazines are a little bit more difficult only because it requires a little bit more understanding of firearms technology, and I don't think the justices are great on that, but I think we win both. But I certainly don't see a way to lose the AR-15 case if they have the fortitude to take the case. So I think what may be going on now within the court among the justices is trying to figure out how are they going to resolve these arms ban cases. Are they going to take one case over another case? Do they want to take all three cases? How do they want to? I think there's a lot of jostling going on right now about what to do. And that is why, the reason why it's significant that these cases were rescheduled and not like conference and then relisted is because they don't want to go to conference. One or more justices has decided don't go to conference and make a final decision on whether or not to hear this case yet, because we want to figure out strategically internally what should occur in which sequence, in which order makes the most sense. Do we want to grant cert in one case and put the others on hold and then, just GVR after we decided, or do we just want to resolve them all together? It is not unusual if you're dealing with interrelated cases with a lot of related issues to grant cert on two of them and hear the argument together. I could see a situation where we wake up in the month of March or April, let's say, and there's an oral argument where the first hour goes to the AR-15 ban case and the second hour is dedicated to the magazine case, and the next day's oral argument is dedicated to the preliminary injunction standards in arms ban cases. I could see that occurring because, again, remember, the Supreme Court is not just about fixing errors of the lower courts. This is very important to understand. Remember, I've always told you there's a difference between cases being important and cases being precedential. The Supreme Court doesn't care that a case is important per se, because every single case is important to the people involved in the case. So every case is necessarily important, period. The question the Supreme Court asks is this case precedential, meaning it can set a precedent that can be followed by the lower courts for years, if not decades to come. So always draw that distinction when you're talking about Supreme Court litigation, which is a unique thing, unique to the Supreme Court as a general matter. Don't confuse important cases with precedential. The Supreme Court cares about precedential cases because, again, every case is important in American life, but they're not all precedential. Some of them are not precedential because the law has already been established. You're just applying existing law, like the law of murder, to a new set of facts, but the law has already been established and has been established. The precedent has been established. So anyway, I think the fact the Supreme Court has denied certain Second Amendment cases for this term, they adjusted the schedule in Rigby versus Jennings, and they've rescheduled these two arms ban cases, tells me something good is going to occur. Something good is going to occur out of all of this. And as long as the Supreme Court is trying to flesh out Second Amendment jurisprudence, which they are right now, well, I think there is going to have to take at least one Second Amendment case applying Heller or Bruin every term to continue, until they have an ample body of case law, which they don't. They have a lot of case law, very well-established case law, but there's a lot more that can be done, obviously. So I think that's how Chief Justice John Roberts is thinking about this. It's time to flesh out, Second Amendment jurisprudence a little bit more. And the way to do this is to take one Second Amendment-related case or one Second Amendment case every term until you have more of an ample body of case law. That's my guess, but only time will tell. I don't control the Supreme Court. I can just tell you what I think's going on. I'm pretty good at this, but I feel pretty good about this. I'm optimistic with what the developments are at the Supreme Court. We'll see if I'm proven true in about a month. All right, folks, hope you enjoyed today's episode. Make sure you follow me on @4boxesdiner. We have over 20,000 followers on X now. A lot of great information over there, and of course, it's free. Make sure you vote for 4 Boxes Diner, Top Voices of the 2A on the Gundy Awards 2025, Las Vegas in January. Hope we can go out there and win an award. And last but not least, make sure you subscribe to this channel and share it with your friends. Don't forget, I'm now on Rumble. I've now added the channel on Rumble. I know a lot of people want to watch my content on Rumble, so I am now posting my videos on Rumble as a courtesy to my fans over on that platform. Okay, folks, hope you enjoyed it, and I look forward to talking to you all real soon here at the 4 Boxes Diner.
Orders up. Table 2A.